So this is one in a series of Hot Topics lectures where we have people from our faculty and from our community and come speak to us on interesting and important topics of the day. And hey, come on in, Yenmei. Come on in. Sit up. We need more people up front. So it's a particular pleasure for me today to introduce our speaker, Mike Myers. Mike was and I were in law school together, and I'll just frame this up. I've just been in a strategic plan conversation with the U.S.-Asia Partnership, and we were talking about what are our ultimate. And some of you have been through this, right? What's the goal and outcome, or strategy, and all those things. So I won't try to parse all that for you, but I'll say that we're ultimately we identified a set of key ultimate outcomes that involve protecting public health and promoting social justice and ultimately stabilizing our climate as the central issue that our generation needs to address. And as we looked backwards towards the ways in which our law school and the program in particular focuses on that, is to build the capacity in Southeast Asian countries to have the rule of law, the systems of law in place that will achieve those goals. And it's similar, I think, for us as an institution, as a law school. And the ways that we do that, one of the key ways that we discussed was building that next generation of leaders, of advocates, of problem solvers that will achieve that. And we have with us today one of our proudest accomplishments in that regard. In the form of Mike Myers, who graduated here in 1993, and since then has served in a variety of different roles. But he's been in the New York Attorney General's office as the chief of their affirmative litigation section, where he oversees a lot of their work on climate cases, including the litigation over the greenhouse gas regulations that the EPA produced, and has been central to the Clean Power Plan litigation. There's other things that he'll list that are significant accomplishments. Or he could list, but I won't go into because I don't want to take his time, because I'm very anxious to hear more about his update and report on where we are with the Clean Power Plan. So present us with a case of whiplash. Thank you.
Thank you, Dave. Can everyone hear me? Okay, thank you. Dave, great to see you again. It's hard to believe it's been 25 years since we were sitting at these desks, although this hall wasn't even here 25 years ago. But it's great to be here and great to see Pat. Thinking about being in law school and what I wanted to do when I got out of law school, it was definitely to work on high-impact environmental litigation. So having an opportunity to litigate the Clean Power Plan has been, one of those opportunities that you really aspire towards when you're in law school. So it's, although the story hasn't been fully written yet, it's definitely been, one of those cases that as you're studying hard and, trying to get good grades and think about what you're going to do next, it's definitely been a great experience for me so far. As I was driving here and thinking about the title of this presentation, which has a case of whiplash, I was thinking that that's not quite accurate. Certainly there has been a bit of a whiplash over the last 6 months, but really the litigation concerning curbing greenhouse gas emissions from power plants has been a very long journey, and it's been one that the New York Attorney General's office has had a role in pretty much from the outset. So maybe there has been a bit of whiplash lately, but I think you might think of it as sort of a long roller coaster ride that we haven't quite gotten to the end of the ride yet. But there have certainly been some interesting twists and turns. So thinking about that long ride and sort of giving you some background to understand the litigation itself, let me go to some slides here. Do that. All right, so this is a very important piece of the context here. We're talking about a national problem, an international problem, right? Climate change and trying to deal with greenhouse gas emissions from the largest source, fossil fuel power plants. So clearly a problem that cries out for congressional action. But this is what we have. I mean, you think about all of the laws that Congress passed between 1970 and 1990 on the environmental side, and what have we had in addressing this critical problem of climate change? Well, the slide speaks for itself. So what about the New York AG's office? Why do we have a role in trying to deal with this national problem? Well, obviously we recognize that there's been an absence of leadership at the federal scale, but given the way that our office works and the legal tools that we have available, how is it that we've been able to do something, to be a player, to try and move the ball forward? And there are three legal strategies that we have employed since my time in the office that are all relevant to the Clean Power Plan litigation. The first one is to either compel or defend the ability of EPA to regulate greenhouse gas emissions under the Clean Air Act. And we brought a case back in 2006 at the same time that we were involved in the litigation with Massachusetts suing EPA concerning greenhouse gas emissions from motor vehicles. This was the companion case to Massachusetts concerning power plants. And our theory there was that EPA had a legal obligation under Section 111 of the Clean Air Act to regulate power plant emissions, greenhouse gas emissions, because those emissions endanger public health and welfare. So that case, after the Supreme Court came out with its decision in Mass versus EPA, just like Mass versus EPA was sent back to the agency for further proceedings, so was the New York versus EPA case, because EPA was relying upon the same theory that the Supreme Court found was not appropriate in Massachusetts, and that was that they lacked the authority under the Clean Air Act to regulate these emissions. So back we went to the agency. That case was eventually settled in 2010 once the Obama administration came in, and that settlement required EPA to go ahead with regulating new power plants under Section 111B of the Clean Air Act and existing power plants under 111D. And that's what wound up being the Clean Power Plan. Now at the same time, again, this is back in the mid-2000s, at a time when the Bush administration was taking the position that they lacked the authority under the Clean Air Act to regulate greenhouse gas emissions, we turned to another tool that our office had used in the past, and that was using common law public nuisance. We had predominantly used that doctrine to go after sources of pollution in state, where we didn't have a statutory remedy. But the same theory we applied to the Connecticut versus AEP case, and our thinking was, if we don't think EPA is right, that they don't have the authority under the Clean Air Act to get at these emissions, but if they are right, then there should be the ability under the common law to get at those same emissions, greenhouse gas emissions from fossil fuel power plants. And our theory was that these emissions were causing public nuisance in the form of harmful climate change impacts, and that we should be able to remedy those emissions, at least by requiring those companies to cap and reduce their emissions over time. And this is a decision that has played an important role in the Clean Power Plan litigation, as I'll mention later. The third strategy is just to defend the right of the state, in this case the state of New York, when it is sort of going beyond what the federal government is requiring. And in particular, New York has been involved with Vermont and 8 other states as part of the Regional Greenhouse Gas Initiative. And that is a program that regulates fossil fuel power plants, requires them to limit the amount of carbon emissions using a cap and trade type of a program. So our office was also involved in defending New York's participation in that program against legal challenges that were brought. And the RGGI program is something that EPA looked at when it did the Clean Power Plan rulemaking. All right, so in terms of the Clean Power Plan, just to give you a quick sense of the statutory background here, I mentioned Section 111D of the Clean Air Act as the provision that EPA used to issue the regulation. Really, that is a provision of the Clean Air Act that kind of embodies this idea of cooperative federalism. And that is that there are certain assigned roles to EPA and there are certain assigned roles to states. And, you know, looking at it from sort of a big picture, it's very similar to the National Ambient Air Quality Standards Program in that EPA determines a safe level of pollution and then looks to the states to figure out the best way to get to that level of pollution reduction. EPA has important oversight responsibilities under this cooperative federalism framework. That's to ensure that there's a baseline and you don't have states competing against each other in a so-called race to the bottom, as it's been called, to make sure there's a base level of protection. And another hallmark of cooperative federalism is a state has the option, if it chooses, not to implement a program, in which case EPA will step in and directly regulate the polluting sources in question. So one of the most important legal issues and one of the most interesting legal issues that came up in the Clean Power Plan rulemaking and also the litigation is this question of the best system of emission reduction and what can EPA consider as that best system. Well, the statute under Section 111 directs EPA to figure out what the best system of emission reduction is that's been adequately demonstrated. And then for issuing regulations under Section 111D, they're required to come up with these emission guidelines that reflect the application of that best system to whatever the sources are in question. And here we're talking about power plants. That best system determination requires EPA to consider a number of factors. It has to consider the nature of the pollutant, how the industry works, what is the amount of emission reduction you can get through applying different systems. What's the cost? How much will it cost to reduce emissions using a particular system? And how does it impact the energy needs of that particular industry sector? Now, the Supreme Court in the American Electric Power case looked at and commented on Section 111D. And, you know, in that case, again, we were taking the position that if EPA lacked the authority under the Clean Air Act to regulate these emissions, then federal common law public nuisance should apply. And the court found that, in fact, our common law nuisance remedy under federal common law had been displaced by the Clean Air Act. And one of the things that they talked about was they pointed to these factors in Section 111 and said, look, Congress directed EPA to do this, what the court referred to as a complex balancing of these factors to figure out the amount of pollution reduction from these sources that's appropriate. And, you know, that is not the type of analysis that the court thought was appropriate for judges to do. It really is something that Congress entrusted to EPA. So one of the interesting things when EPA set out to write this regulation was they confronted some challenges that they might not face under other regulations that they've done in the past. One of them was the lack of a widely available and cost-effective, what we might call bolt-on technology, the equivalent of putting a scrubber for SO2 on a power plant. Now, certainly, technologies such as carbon capture and sequestration are out there. They've been used, they've been demonstrated, but, they have not matured to the sense that they're widely available and cost-effective no matter, where you are in the country. So that was one difficulty that EPA had to try and figure out how to write a regulation that would get meaningful emission reductions, but at the same time, keep in mind that, the technology fix or the pollution control fix was going to have to be a little bit different than under previous regulations. Another second factor that made this a challenge was that states in 2013, when EPA was writing this regulation, were at different points in terms of how their energy mix in terms of energy generation had changed. And, focused on emission reductions because of New York's participation in the greenhouse gas regional greenhouse gas initiative, we had already reduced our carbon emissions by 40% at about the time that EPA was coming out with the proposed Clean Power Plan. Yet you had other states, Arkansas's emissions had gone up by 40% from 2005 to 2013. And you had, states were really kind of all over the board. Some had significantly decreased, others significantly increased, and others were, more or less the same. So thinking about the equitable implications of, writing a nationwide regulation, but keeping in mind that states are at different starting points was one of the challenges that EPA had to face. Another one concerned the different energy mixes. And this is, just an example of how different states get their electricity generation. I mean, you have, Idaho gets 71% from hydro. Kentucky gets 92% of its power from coal. So, and there are obviously, lots of mixes in there. New York has a fair amount of nuclear. So, trying to figure out again, how do you come up with a regulation that is equitable, that gets meaningful emission reductions, that takes into account the realities of how states generate power, was a challenge. So what did EPA come up with? They determined that the best system of emission reduction was a combination of three, what they call building blocks: increasing efficiency at coal plants, relying on more natural gas combined cycle generation, and also relying more on renewables and less on fossil fuel-based coal and natural gas. And these building blocks 2 and 3 have been referred to as generation shifting, because you're really moving towards cleaner generation to generate the same amount of electricity. And EPA looked at that in the Regional Greenhouse Gas Initiative, as well as other state programs like Renewable Portfolio Standards, that states had been able to achieve significant and also cost-effective emission reductions by relying upon these building blocks 2 and 3 in particular. And EPA did look at, but rejected methods of emission reduction that were just limited to what a power plant could do on site. They pointed to things such as CCS, co-firing of coal with natural gas as ways that you could get emission reductions, but rejected that those were the best, primarily for cost reasons. So what EPA projected was that if states went ahead and implemented these guidelines, that by 2030 we would see an emission reduction of 32% compared to 2005. Or if you compare it to where EPA expected 2020 levels of greenhouse gases to be, a 16% reduction. And EPA provided for this phased-in approach where the compliance obligations would not begin until 2022. So what's the big deal? 16% below 2020, 32% below 2005. Doesn't sound like all that much, right? Well, it's a big deal because in the aggregate, we're talking about the largest source of greenhouse gas emissions in the country. So if you're asking each state to do something, those reductions are going to add up at the end of the day. And for that reason, it also provided the U.S., I think, with some necessary credibility for us to go to Paris and say, hey, we're serious. We're serious about reducing our greenhouse gas emissions. And here's what we're planning to do, and here are the emission reductions we're going to get from our power sector. All right, so let's talk about the litigation now. I think it would be an understatement to say that this was a hotly contested case. In fact, EPA was sued over the proposed rule. The opponents did not even wait till EPA had finished the rule to file suit. But after that litigation was dismissed on the grounds that it was prematurely brought, right? The litigation over the final rule involved 45 of the 50 states. So New York was one of the 18 states that intervened on the side of EPA. You had power companies on both sides of the case. Obviously you had a number of extractive industries who were challenging. And we also had an incredible amount of amicus participation. And Pat Parento did an excellent brief on the side of the of EPA. But you can get a sense of what some of the different briefs were that were filed. And one of the briefs that came in on the side of EPA was written by a group of grid experts who I think did a really good job of explaining to the court how the electricity grid works and how there's this interrelationship between how power plants come on and go off, that really on this issue of generation shifting educated the court, and that's what a good amicus brief should do. And the court, on a couple of occasions, referenced this grid experts brief. But I think we did very well in terms of having a well-rounded support from the business community and from scientists and from former EPA administrators and secretaries of state. And interestingly, from a number of cities that you might not expect would be supportive of the Clean Power Plan. Salt Lake City, Houston, Dallas were among the 54 cities that came in supporting the Clean Power Plan. And I think, you had a situation where you had states and cities in those states on opposite sides of the V, which made for one of the more interesting dynamics, I think, in the litigation. So I've put up here what were referred to in the litigation as sort of the core legal issues. There were core legal issues, and then there were record-based issues. So these are the core legal issues. And I've alluded already a couple of times to this question of what's the best system of emission reduction. And from a legal standpoint, what that really boiled down to was, can EPA look, or is EPA required even to look beyond the fence line? Because that's how this power sector has shown they can cost effectively get emission reductions in CO2. Another interesting issue is this question of whether EPA even has the authority under Section 111D to regulate CO2 from power plants, because EPA is under a different provision of the Clean Air Act, Section 112, the hazardous air pollution provision, regulating these same power plants. Different pollutant, mercury is obviously not the same as CO2, but the legal argument was based on the way that Congress amended the statute in 1990, the plain reading of the text, which we didn't agree with, but the argument was the plain reading of the text is it prevents EPA from regulating under 111D sources that are already being regulated under Section 112. The third one really got to this cooperative federalism theme that I mentioned earlier, and that is, did EPA in writing the rule cross the line in terms of dictating what states have to do as opposed to setting the overall pollution reduction levels and allowing states to choose how to get there? So that was that third issue. And, coming in, I think that was one of those issues that if you're a state who's coming in in support of EPA, you can allay any fears that the court has that EPA has crossed those boundaries by explaining how it is that you in fact retain the ability to have a say as to how those reductions are achieved. And the last core argument was a constitutional one. And kind of dovetailing off this issue of whether EPA crossed a line in terms of telling states what they have to do, the argument was that under the 10th Amendment, the ability to choose how your state's going to generate electricity is this constitutional right that EPA, by in particular coming up with the generation shifting aspect of the rule, was in fact telling states how their energy mix had to be used, and that violated the 10th Amendment, which, again, that was a situation where, as a state supporting the rule, we were in position to explain to the court why, in fact, that was not the case. So before the election, here's the way that the litigation rolled out in some of in terms of some of the milestones. So the litigation started in October of 2015. Shortly after that, we had a very intensive period of briefing stay motions. So what happened was a number of the challengers filed motions for stay of the rule in the DC Circuit. And unlike when you are just doing your merits brief and everything's limited to the record that the agency created, when you're briefing a motion for a stay, the court considers outside evidence. So one of the things that we did as part of that stay briefing was gather affidavits from state agencies that were in our states talking about how the Clean Power Plan was a workable regulation, how there was sufficient time for states to be able to design a plan that would allow their power sector to come into compliance with the rule. And we were successful at the DC Circuit level in having those motions denied. The court found unanimously by a 3-judge panel that the petitioners had not met the standard to show a stay or to be able to get a stay. However, the challengers went to the Supreme Court, and a month later, by a 5-4 vote, the Supreme Court granted a stay of the rule pending the resolution of the litigation on the merits. We went ahead then, the DC Circuit had already ordered expedited briefing of the case, so we went ahead with the merits briefing. That was concluded appropriately on Earth Day in 2016. And we filed briefs that addressed both these core legal issues that I was just referring to and also record-based issues. These were challenges, as you would think, based on the claims that the record did not support the level of emission reductions that EPA concluded was possible under the regulation. So after we filed our merits briefs, we went ahead with oral argument, and initially we were supposed to have oral argument before a 3-judge panel in June of 2016, and we were getting ready for oral arguments, and then all of a sudden a week before, we got an order from the DC Circuit that they had decided to hear the case en banc, and they pushed the argument back until the end of September and scheduled it for a full day of oral argument. And I was fortunate enough to be one of the about 15 or so attorneys who argued that day, and it was a full day. We got to court at, I think we started at 9:30. We took like an hour break for lunch, and we left at 6 o'clock. So the court definitely spent a lot of time, going through these issues very systematically. It was a pretty amazing experience, and you felt very good about the experience because you knew that the court was taking these issues very seriously, asked a lot of difficult questions to try and kind of grapple with some of these legal issues. So then there was this election that happened in November. And as you're well aware, the Clean Power Plan was on the hit list of the Trump administration from the outset. And but here we are, right? The case was fully submitted, end of September. And so we were waiting for a decision, and no decision was forthcoming. So a couple of months after the administration, or after the inauguration, I should say, EPA filed a motion for an abeyance, which is essentially asked the court to freeze the case so that the new administration could review the rule and decide if it wanted to undertake new rulemaking to change it. So we went through an additional round of briefing. The court asked us to provide supplemental briefing on what should happen next. So we submitted those briefs in early April, and then towards the end of April, the court came out with an order, very short, one-page order, that said that they would be granting essentially a temporary abeyance. EPA had asked for an indefinite abeyance until it figured out what it was going to do next. And the court declined to give them that. They gave them a 60-day abeyance, which has now expired. It expired at the end of June, which sort of puts us in kind of I don't know if we're back in limbo to where we were when we were waiting for a decision. One other development to mention is that EPA did notify the court in mid-June that it had sent over to the Office of Management and Budget for Interagency Review a proposed rule concerning the Clean Power Plan. Now, it didn't say what the rule would propose to do. It was reported at the time that that proposal would be a rescission of the Clean Power Plan. But there's been no official steps that have been taken since then so that we would actually see what they're intending to do. So what happens next? Can they just rescind the Clean Power Plan without any plans to replace it? That seemed to be what the press accounts were saying at the time that they were proposing to do. Interestingly, though, if they intend to rely on this argument that Administrator Pruitt, when he was at the Oklahoma AG's office, fully embraced, and that was EPA lacks the authority to look beyond the fence line to consider these generation-shifting measures of emission reduction. Well, if that's the way they're going to go with this as a basis for rescission, that would still leave in place EPA's duty to regulate power plant emissions under Section 111D. So in a way, that doesn't get them off the hook. And certainly New York would be one of the states that would be pressing in court for them to move forward with something. The whole repeal and replace has some resonance these days. And it is similar, I think, in a sense. And so one of the most important legal issues going forward is, can EPA ignore how the power sector has been able to most cost effectively get these emission reductions in a way that has, both maintained reliability and, in our experience, has, kept electricity prices down as well. There's some interesting questions, I think, both of statutory interpretation. If you think about this as a, Chevron Step 2 question, EPA gets to interpret what the best system of emission reduction is. Well, if they are not considering how the power sector has reduced emissions most cost effectively and has told EPA how they're going to, in the future, reduce those emissions, regardless of how EPA sets the standard, is that an unreasonable interpretation under Chevron Step 2? Or on a related note, if you think about just general principles of administrative law, an agency can't ignore relevant evidence in the record. So if you have this compelling evidence that this is how power companies are reducing their CO2 emissions, would that violate sort of basic principles of administrative law if they said, sorry, we can't look at that, we can't consider that? So I think that's going to be another interesting legal issue no matter what the agency does going forward. So that's what I had in terms of the initial presentation. I'm happy to take questions at this time.
Thanks. A round of applause. That was great. Thank you.
So, Mike, I'm intrigued by that last point. As the amicus briefs and your briefs pointed out, EPA has gone beyond the fence line numerous times under a variety of sections, including 111D. So under the State Farm Mutual test, that you have to have a reasoned analysis for changing your position on that question, how do you think they're going to do that? And how do you think the court might view a flat statement that we don't have the authority to go beyond the fence line when 4 different administrations have done it?
Yeah, I mean, it's a very good point, and certainly something that we pointed to in the briefing that, well, look, I mean, scrubbers are manufactured off-site. You have, if you go back, a better example I thought was if you go back to the first time EPA set one of these new source performance standards for, I think it was for SO2, EPA looked at how power plants could have the coal washed off-site before it was actually burned in the boiler, and they considered that when they set the standard. So yeah, I mean, I think that's a really good example of, well, you say you don't have the authority, but in fact, in the past, you have exercised that authority. So, I mean, they could go with a very sort of textual argument under the Clean Air Act that we are prohibited from looking beyond the fence line. And even if we did it in the past, if the agency does something unlawful in the past, doesn't mean they can do something unlawful now, right? You see that argument made. But I think, thinking about how the oral argument went, the court did not seem to be convinced by the argument that the petitioners were making that the text of the Clean Air Act prohibited EPA from looking at these, building block 2 and 3 generation shifting type measures. And, repeatedly pressed petitioners' counsel for where exactly is that? And I think what the petitioners tried to do, in addition to just, doing the best they could with the statutory language, was to say, yes, but, under Supreme Court case law, you shouldn't be looking whether or not this interpretation is prohibited. You should be looking whether or not it's affirmatively, the authority's been affirmatively given to EPA to do this type of interpretation, citing the UARG case and a couple of other cases concerning the major questions canon, which Judge Kavanaugh spent, probably about 10 minutes talking about that and how, isn't there some affirmative basis for authority when you have this transformative rule? And I think, again, really interesting legal arguments. One is it's not a transformative rule because the power sector is already doing this. I mean, yes, maybe you're accelerating a movement towards cleaner generation, but you're not transforming the industry. So I think that's one of the rebuttals that we'll see. And the other one is just, those Supreme Court cases, are fact specific to those situations, so therefore it doesn't apply here.
I have a question, Mike. Do you have any insights into why the EPA has decided to pursue this path of trying to withdraw the rule? Do we have any inside information that reflects they're afraid of what the D.C. Circuit would decide and that they're afraid that it would be upheld? Because it seems like if the D.C. Circuit were to find that the rule was beyond EPA's authority, that would be the easiest path for the administration to not move forward with this program.
It would be. Yeah, no, I agree with that. I think it's concern, that the court will find that EPA has the authority to do what they did. And, you always want to be careful about predicting outcomes based on oral argument. But I think the consensus coming out of oral argument was that EPA and its supporters had the better of the argument. And, certainly the beyond the fence line argument where the court took about 2.5 hours of the, full, whatever, we were there for about 8 hours. So that's where the focus really was. I think that the new EPA has to recognize that if they rolled the dice and just went forward with the litigation, there's a decent chance that the Clean Power Plan would be upheld.
Thanks.
And I'll just say one more thing, just adding to that when you were involved in these cases as an intervener, as opposed to a party who's, challenging a regulation or defending a regulation, sometimes you wonder, is all this briefing, is all this argument worth it? Is the court even listening? Do they care? And I think this was a situation where we did feel like, especially after oral argument, the court did care and they were interested. And just to cite one example, during this argument about the best system of emission reduction, after the DOJ attorney went, then I argued, and the attorney from the power companies who were supporting EPA, Kevin Polenkaris, argued. After we sat down and the petitioners got back up for their rebuttal, several of the judges really picked up on some of the points that we had made in terms of just a very practical argument that this is the way these emission reductions happen from this sector. Why would you ignore that? It's perfectly reasonable that EPA considered those practical measures when they were setting the standard. And so the court kind of came back at the petitioners with that, and they didn't really have a very good response, I don't think. I mean, again, they sort of said, well, but the text of the statute doesn't allow EPA to do that, or, well, yeah, some of us agree that you should have more flexible means to comply, but not when EPA is setting the standard. And I thought that was something where the interveners really worked together with DOJ to kind of fill in some of the practical aspects to the rule that DOJ was really more focused on the statute and the statutory text. But I thought it was a really effective combination that worked in that case.
Thanks, Mike. It's a fascinating but also terribly sad story.
Not over yet, though.
Not over, but it certainly isn't over yet, as your last cartoon illustrates. In terms of the practical side of things, you just mentioned the word practical there. There's lots to talk about. I think it's fair to say that, of course, an underlying agenda of the Clean Power Plan was trying to reduce coal emissions, explicitly or implicitly. But then, what word you hear when you read the energy news is that the fracking capabilities and the availability of natural gas and the sort of shift in the energy mix and the reduced price of renewables is driving, the market's driving this all anyway. To what degree would you, and let's just assuming the Trump administration is successful in putting the Clean Power Plan to bed for 4 years, to what degree do you see the line in terms of what the Clean Power Plan would have accomplished versus what the market's likely to accomplish? And I know you're a lawyer, not an economist, but I'm interested.
Well, it's a really good question. And I think we've seen that, even without the Clean Power Plan in place, since the Supreme Court issued the stay, that the market has continued to, push towards cleaner generation. Coal has continued to decrease overall. You've seen more renewables. So I think, one of just thinking about regulation in general, why do you need it, right? Well, you don't need it if the market's working in your favor, right? If the market is really incentivizing cleaner generation. But the market doesn't always work, right? That's why you have regulation in the first place. And I think, based on some of the modeling that was done, both before the Clean Power Plan came out and now since the Clean Power Plan, the expectation is certainly as you get further towards 2030, that having a backstop regulation in place that is requiring emission reductions will become more important. And obviously, it gets harder to predict the market as time goes on. So I think, certainly having it in place makes a lot of sense in addition to just why we have regulations in the first place.
Other questions, comments?
Let's speculate a little bit on what's going on in the chambers. Because,
This is where I have to turn off the stream live.
one thing the court might be waiting for is to see exactly what Pruitt's proposing, right? And if he proposes something that says, I don't have the authority to do this, do you think that might prod the court to decide to go ahead and decide the case? Is there something that Pruitt might do that would say to the court, we really do have to issue a decision at this point, since we've briefed it and heard of the argument and all that?
It's a really excellent point. And actually, when we did the opposed EPA's motion for an abeyance and then submitted our supplemental briefs, we made that very point. And that is, look, this question of EPA's statutory authority is not going to go away, regardless of what they come up with.
It's going to be back here.
Right.
In fact, it's going to be back before us.
Yeah.
So why do we do this again?
Yeah. Well, and actually, we had briefed this Section 112 issue in the proposed rule challenge. So we would have to brief that one a third time if the court decides not to rule on the merits. So, yeah, I think certainly if they come out with a proposal that is, we don't have the authority, then that makes that argument even stronger that, well, geez, the case has been fully briefed. Why doesn't the court just go ahead and issue a decision? The more they come up with something that's a replacement, then I think that, makes the argument stronger that, well, maybe we should wait until that fully spins out until we decide what to do next.
And if we get a decision, what's it going to be? What's the count? It's not going to be unanimous, right? 10 judges, right?
10 judges, that's right. Judge Garland did not participate because at the time his Supreme Court nomination was pending. I think that it's reasonable to assume that you would have a split among the judges. Although I think, because the court did break this up into different sort of issue areas, that you could see unanimous opinions on certain aspects of it. But certainly the best system of emission reduction, which was generated the most questions from the judges, I would expect there would probably be, a split decision on that.
Okay, thanks.
Great. Well, please join me in thanking Mike for this presentation. Thank you.
You're welcome.